Good afternoon, everyone, and welcome to our continuing updates on the coronavirus. I'm just going to give everyone a minute here to get logged in. I see the numbers rising as we go. Two quick housekeeping items. First of all, feel free to use the Q&A function to submit some questions today. We'll do the best we can to answer those questions. Some of them are very fact-specific, however, experience tells us. So to the extent that those are your questions, you may need to speak to your attorney on the side. It's a little bit difficult for us to answer every scenario in the context of a 45-minute webinar. The other thing is it's very helpful for us if you can, at the end, submit the survey. We appreciate your feedback. Okay, so with that, let's get started with today's webinar. We've got a very full agenda for you. My name is Pete Jones, and I'd like to introduce, starting us off today, Teresa Rusnick and Carrie Langen. They are going to take us through the New York paid sick leave, which is not strictly speaking a COVID topic, but certainly interplays with COVID emergency sick leave, and will be with us in January when we still have COVID, it looks like, to be dealing with. Take it away.
All right, thanks, Pete. So I'm Teresa Rusnick. I'm going to start us off by talking about some basics of paid sick leave and what the guidance that came out last week really addressed. Then Carrie's going to pick it up with some of the more complicated issues and talk about what possibly we could be expecting from New York State as we go forward, because for those of you that have had the opportunity to read the guidance, you know that it didn't answer certainly all of our questions and that there's much more information that we're hoping to get from the state. So the guidance that I'm referring to was published on October 20th. So last week. It is New York State paid sick leave guidance. So I know we've been waiting for that. It did address a couple of things that I'm going to talk about on the big three. So use, carryover, and accrual. So, you know, even before we get to that, one of the things that I know a lot of companies, employers have been wondering is how to calculate their size. How do we count our number of employees? Do we have to count out-of-state employees? Do we count employees in other countries? You know, how do we count employee size for determining if we're going to offer 40 or 56 hours of leave? And unfortunately, that is something that the guidance did not answer, which is with as much specificity as we would have liked. However, the guidance did say that if you're a New York entity and you have offices across the state, all of the employees in each of those offices would count towards your total. So even if you have less than 100 employees in any one office, if your total for New York offices is over 100 employees, you would have to offer the higher amount or the 56 hours of paid sick leave to all of your employees. Another question we had been getting a lot is, how do you define hours worked for purposes of accrual? If you remember, the statute had said PSL only accrues for hours worked. And so we got some clarification on that in the guidance. We got clarification on the fact that hours worked does not include sick time. So time does not accrue for paid sick leave purposes when an employee is using sick leave. However, the guidance provides that time worked may include on-call time, training time, and travel time, especially if the employer already considers that to be time worked and compensates the employee for it. Another big thing we learned from the guidance is that accrual or front loading can be capped at the 40 or 56 hours. So even if an employee would have worked and earned or gained more than 40 or 56 hours on their usual work schedule using the 1 hour for every 30 hours worked method, you can cap them at 40 or 56 hours whenever they reach that accrual point during the year. And then one of the other questions that the guidance attempted to answer, and I think this is one they gave more detail on than some of the others, is how do we front load leave for part-time employees? I know a number of employers have been wondering about that, especially if they were going to front load for full-time employees, how they did that for part-time. So the guidance basically said that if you want to front load for part-time employees, you need to look at the amount of hours that the employee is expected to work over the coming year, divide that by 30, and provide enough leave so that if the person had been using the accrual method, it's roughly approximate to what they would have gotten if you were going to front load the leave. Now, the guidance did say that if you weren't going to track the paid sick leave usage and accruals throughout the year, then you needed to front load the full amount. So even if you front load a partial amount of the leave, you still need to track usage and accruals throughout the year. So that was what they said on front loading for part-time employees. For out-of-state employees, unfortunately, they didn't tell us how to count them for purposes of overall employer qualification size, but they did say that when out-of-state employees are working in New York, that's when they accrue time for paid sick leave purposes, and that appears to apply even if the employer is located primarily outside of New York. Turning to carryover, I know this is another big one, and I think one of the ones that the guidance really could have done a much better job at answering, because if you look at it, it's a bit inherently contradictory on what is supposed to happen with carryover. But sticking with the statute, the guidance did say that employees are allowed to carry over accrued unused leave. It left open whether or not carryover can be capped at 40 or 56 hours or at another number. And it also really left open the question of if an employer front loads leave at the beginning of the year, does the employer still have to allow carryover? The text of the statute and the text of the guidance largely would suggest yes, but there is some different support for that in a small section of the guidance as well. So on that one, I think we are still waiting for more information from the state in particular. Then wrapping it up with use before I turn you over to Carrie, you know that the statute was probably the most specific when it came to use, and the guidance doesn't contradict any of those use purposes set out by the statute. It does explicitly say that paid sick leave can be used for medical and dental appointments, even if they're routine. It also says that employers do not have to allow paid sick leave for bereavement purposes, for those of you that were wondering about that. And then that paid sick leave may or may not be available in public health emergencies, depending on the nature of the emergency. And I'm going to turn it over to Carrie to pick up with more paid sick leave updates.
Okay, thanks, Teresa. Hello, everyone. So the guidance also addressed telecommuting. It says that employers cannot require employees to telecommute instead of taking paid sick leave. However, you can always offer that as an option. If you do offer that as an option, though, be careful because you can't then require the employee to use their time as well. So if you offer telecommuting as an option, you can't use down their sick leave accruals. The guidance, unfortunately, did not define the regular rate. We were hoping that we would get a definition of what it means to be, you have to pay sick leave at the regular rate. We learned a few things, though. You are not required to pay an overtime rate. So if the paid sick leave would have been overtime when worked by the employee, you don't have to pay them at the overtime rate. If you have employees that are paid on a commission or flat rate basis or a non-hourly basis, they accrue sick leave based on the actual length of time that they have spent performing work. So I think that's a helpful clarification. You don't have to include tips or gratuities in the regular rate calculation as long as the employee is at least paid their rate of pay or minimum wage. They at least have to be paid minimum wage. And employees who are paid at more than one rate of pay have to be paid at the weighted average of those rates of pay. The guidance also stated that you can allow an employee to elect, if an employer could elect to allow an employee to elect to use their sick time concurrently with paid family leave to get their pay up to 100%. So if an employee wants to get their $840 of paid family leave, they can then use any accrued sick time, assuming it qualifies, to get up to 100%. What you just have to be careful about is that you're not allowing the employee to go over 100% of their pay. Record keeping, we also have some guidance on record keeping. Employers have to keep all payroll records for 6 years. And included in that is the amount of sick leave that employees have used and accrued on a weekly basis. So you have to keep those records for at least 6 years. We know this from the statute, from the law, that if an employee requests a summary of the amount of leave used and accrued, you have to provide that summary to them within 3 business days of their request. We have a little more information in the guidance on notice. So unfortunately, we were hoping to see some type of, there's no specific amount of time that is required. So employees just have to give notice in advance of taking sick leave. We can't require them to give notice 2 hours in advance or, an hour in advance. As long as they're providing advance notice, we have to allow them to use the time. But the guidance also specifies that if employers in a policy are going to put limitations in there, on the cap, employees can accrue sick leave up to 40 or up to 56 hours, or employees can use sick leave in 4-hour increments only. That has to be done through the policy. So I think it makes it really important for employers to make sure that their policies are conveying all the information that they need to convey to employees that's required under the law. Some other miscellaneous items, other things that we felt were notable that the guidance addressed and we wanted to highlight for you. Employers cannot impose a waiting period on the use of PSL. So, sometimes it's common for employers to say new hires will start accruing on day one, but they can't use their time until they've worked for the employer for 90 days. That's not permissible. Seasonal employees, the guidance spoke about seasonal employees, and seasonal employees that maintain an ongoing relationship with their employer have to have their balances, their paid sick leave balances restored after their break in employment. So that's, something to keep your eye on. Employers can have a policy that allows employees to donate unused sick leave to a sick bank, but it has to be voluntary on the part of the employee. Employers can discipline employees for inappropriately using paid sick leave, which could include termination of employment. What I think we have to be careful about there is that unfortunately, the guidance did not address the documentation that's allowed. So, some states have paid sick leave laws, and employers are allowed after 3 consecutive days to request a medical note. New York does not allow that. So, yes, we can discipline employees who fraudulently use sick leave, but on the other hand, we can't require documentation at this point. So I think that makes it a little bit challenging. We have to be careful. You certainly cannot assess points under an attendance policy or, count, an absence as unauthorized if somebody's using paid sick leave. Those absences are protected. The guidance also addressed penalties really quickly. Failure to provide paid sick leave is the failure to pay wages. So you could be subject as an employer to civil lawsuits, administrative and criminal penalties, and an order to repay wages. Now, the order to repay wages, there's also, in addition to that, 100% liquidated damages could be assessed, as well as civil penalties in an amount up to double of the total amount due. Aside from that, like Teresa had said earlier, there are a lot of unanswered questions, and I think we've hit on most of those. Recommendations moving forward, we still hope to receive regulations on this from the Department of Labor. So we're waiting to see if we get some additional guidance. In the meantime, you should be looking at your policies, obviously updating them, making sure they're compliant, as far as best as we can for now, right? And then we'll, hope to be back with you with some additional guidance in the future. That's all I have. Thank you.
Thank you, Carrie, and thanks, Teresa. We're getting a lot of very specific questions. I think most of those, we've answered to the best of our ability, but I'm going to suggest that perhaps we'll do just a Q&A session at some point in the near future where we just, pose and answer a lot of these very specific questions in a separate session. With that, let's turn to Laura Harshbarger. Laura is a member here in our Syracuse office, and we've touched on some of these topics, but I think it's a useful time to collect some of our thoughts on, rightsizing and downsizing and furloughs. So Laura, take it away.
Thanks, Pete. Matt, we can go ahead and go to the next slide. This is a very high level view. I mean, we are at 10,000 feet here in touching on any of these topics. As I'm sure you all can imagine, whenever an organization is considering any kind of significant employment action that would involve multiple terminations, a reorganization. Maybe it's elimination of headcount. Maybe that's the goal. Maybe the goal is that one segment of the business, there's no foreseeable need for that level of staffing, but yet there is a need to bulk up personnel staffing in another segment of the business doing better. All of these things are highly, highly complex. They can pose significant liability if not done correctly. And so I can't emphasize enough that if an organization is considering job action that would go in the category of a significant furlough, a significant downsizing, a reorganization, you're absolutely going to want to do that in partnership with counsel. This, though, is to give you a sense or a flavor of some of the things that you will want to pay attention to if your organization is finding a need to downsize or right size. Go ahead, Matt, next slide. First question that often gets asked is it possible to do this on a voluntary basis? And the answer is it may be, depending on the needs of your organization. If the needs of your organization are to eliminate headcount, eliminate personnel, and there is not a strong desire to see particular individuals or particular positions affected, but simply kind of a number that perhaps the organization has in mind, then it is possible to ask for volunteers for these kinds of actions. And whenever something can be achieved on a voluntary basis, that's always better. It just doesn't always fit every situation, of course. So yes, you can ask for volunteers for a layoff, and there is a provision in the unemployment insurance law that provided that this voluntary layoff is being done either pursuant to a collective bargaining agreement or a written employer plan, that employees who voluntarily elect for layoff may still be eligible for unemployment insurance. And obviously that makes something far more attractive to folks. Next slide, Matt. The next question we often get is it lawful to offer an early retirement incentive? And it is. There are parameters within which an early retirement incentive needs to fit. It needs to be voluntary. It needs to be available for a reasonable period of time so that folks have a good chance to really mull that over and decide what's best for them. And there's this very cryptic, for now, term, a retirement incentive may not arbitrarily discriminate on the basis of age. Now, it is perfectly permissible to tie an early retirement incentive to years of service with an organization as well as to age. That's not what we're talking about here. There are certain limitations on how an early retirement incentive is structured, and primarily we can't have benefits decreasing for older employees who may be selecting this benefit as opposed to those who are in a younger age bracket but are also eligible for this set of retirement package and incentives. Early retirement incentives often involve extensions of certain benefits under certain plans. And again, very, very complicated area there. So we'd encourage you to reach out if your organization might be considering an early retirement incentive, as well as to decide whether or not that is an action that will achieve the organization's goals. Next slide, Matt. So now if we, perhaps the organization does not see a way to do this on a voluntary basis and is considering an involuntary reduction in force, the question becomes, what should we be thinking about in these kinds of situations? The first thing to decide is this going to be company-wide? Is this reduction in force going to be limited to specific departments, or is it even particular positions, right? When we get into reorganizations, very often what we're talking about is eliminating very specific positions, combining them with other positions, or transforming them, deciding that the needs of the business are different than the position as presently envisioned. The organization also needs to be very clear on the selection criteria that will be used. If there's a collective bargaining agreement in place, very often seniority will be the rule of the day under a collective bargaining agreement. An employer also could decide to use seniority as the basis, but that's not required. An employer can decide what are the appropriate criteria. Those can include performance. It can include, one's transferability of skills, or the way in which positions may be changing in the future and the different skill sets that may be required. All of those things are permissible, but it's very, very important to do this in a very logical, very planned, very detailed way to determine which individuals will be impacted in a reduction in force and which individuals will not. Next slide, Matt. Are there legal concerns with the reduction in force? Clearly, right? There clearly can be significant pitfalls, that all of which need to be avoided. And this is why that the planning needs to be so careful. There are potentials for disparate treatment claims. That would be someone saying, I'm in a protected class. I believe I was discriminatorily selected for this reduction in force. There also is the potential in a reduction in force for disparate impact claims. And those claims are based on an idea that the company's not intentionally discriminated. That wasn't the intention. The intention was to apply a fairly neutral rule, policy, set of criteria, but it ended up having a disparate impact on a particular protected class of individuals. All of that needs to be looked at very carefully when implementing a reduction in force. Next slide, Matt. There also may be requirements to provide advance notice if a reduction in force is going to be of a certain size. These are very complicated statutes, both at the federal level and at the state level. And frankly, they operate off definitions that are not at all intuitive. The definitions within these statutes are very particular. These phrases are very particular to the statute. Again, I can't emphasize enough the importance of getting counsel early before implementing a reduction in force to see if your organization would have obligations for advance notice under either a federal or a state WARN statute. The advance notice is critical. The advance planning is critical because under the federal law, our federal WARN statute, an organization would need to give 60 days advance notice if taking a job action that's covered by WARN, and not all are. And under New York State, an organization would have to provide 90 days of advance notice before taking a job action that is covered by the WARN statute, and not all are. We generally find WARN events in categories of plant closings or mass layoffs. And those, again, are very, very complicated definitions with ways to count employees, those who are affected and not affected. Not at all intuitive language. You'd think we'd know what a plant closing is, but in fact, a plant closing under the statute has a much broader definition than simply shuttering the building. And so please reach out for guidance on any of these things. The number to keep in mind is really 25. If at least 25 employees will be affected by a reduction in force or a downsizing or reorganization, you'll want to know whether or not the action that you have planned is going to fall within the coverage of a WARN statute. And you really need a lawyer to walk you through that to decide if in fact what the job action at issue is covered by a WARN obligation or not. The remedies for failure to provide WARN notice can be significant because they involve back pay and compensation to employees who should have gotten notice but did not receive notice. Next slide, Matt. Finally, severance agreements. Does an employer have to offer a severance agreement in a downsizing? No, absolutely not. Many do, but it's not required. I suppose certainly some employers have severance plans as part of their employee handbook or as part of their otherwise complement of plan benefits, and you should look into that. Similarly, perhaps there is an obligation to provide a severance agreement in a collective bargaining agreement. But as a general rule, these are not required. It's very important if your organization is contemplating offering severance agreements to have those reviewed by legal counsel. There have been recent changes within the past 18 months or so that affect the provisions that are permissible in a severance agreement. So don't pull one out that you used a couple of years ago. It may not be current, and it may not coincide and be compliant with the current state of the law. Additionally, depending on the job action that you are undertaking, if it is a group termination, and their group just means 2 or more terminations happening at the same time and out of the same decision, there are additional obligations that we have to provide a longer period of time for individuals to consider whether or not to sign those agreements, as well as additional disclosures that those individuals must be given. And a failure to abide by those requirements will result in age claims not being validly released. And of course, the whole point, generally speaking, of the severance agreement would be to obtain a full and general release of claims. So again, you'll really want to consult with counsel as you're considering a severance agreement. Okay, thank you, Pete.
Thank you, Laura. A lot of material there, a lot of food for thought. These are things that I think we've all been doing periodically, and unfortunately, we're doing them a little more frequently right now. And it's important to be intentional about how we do it. Make sure we get it right.
Absolutely.
Okay, we're going to turn to Mike Billick. Mike is a member in our Albany office and Saratoga office as well. And Mike's going to give us a little update on OSHA issues. It's a feature we've been periodically doing to make sure you stay current on all your obligations. Go ahead, Mike.
All right. Well, thanks, Pete, and good afternoon. So if you're wondering what OSHA has been up to as far as COVID, well, OSHA's been under a great deal of pressure. There was some hearings before all the nomination hearings, but some hearings on Capitol Hill with the head of the Department of Labor called up asking, what is OSHA doing about the pandemic? Well, at the time, they said that they were about to start issuing some citations. OSHA has a 6-month statute of limitations. That means that OSHA cannot, when they issue a citation, it cannot cover any violation that occurred more than 6 months before when they issued the citation. And now we're starting to see OSHA issue citations for violations that occurred during the month of April. And what OSHA is doing is publicizing this. Every week, OSHA updates its website and issues a press release stating how many establishments they have cited to date regarding COVID and what the total penalties are. And they also list every single cited employer on their website in that press release. So if you are going to receive a citation for COVID, you will be included about 2 weeks after the citation comes out. OSHA will update its website and include your name on that. So to date, at least as of Friday's OSHA's press release, OSHA has cited 112 establishments for violations, resulting in proposed penalties totaling $1.6 million. And OSHA doesn't issue a press release when a citation is vacated or dropped or anything like that. It's just it's out there when they issue it. Now, OSHA does have a list of things that they feel employers should focus on in order to not be cited. One is to implement a written respiratory protection program if you have respirators in the workplace. And again, if you do, to provide a medical evaluation, respirator fit testing, train on the proper use of respirators and personal protective equipment. Now, this does get into the question, and we're seeing this with some of our clients, what about N95s? If N95 use is voluntary and purely voluntary, just like other dust masks are voluntary, then you don't have to do most of what is required under the respirator standard in OSHA. You do have to supply what's known as Appendix D in the standard. It's giving employees notice that of their voluntary use of the respirator, but you don't have to do everything else, such as fit testing, medical evaluation, etc. However, if a hazard is present such that a respirator is necessary, OSHA is not going to look at that wearing of the N95 as voluntary. So it gets into these sort of complex issues that we're starting to see with our clients in these citations. Other things that OSHA says in the press release that employers should focus on in order to avoid these types of citations: report injury, illnesses, or fatalities, of course, as you're required to do so in your record keeping criteria, and to do it on your record keeping forms, and to report hospitalizations and fatalities as required. Now, this gets into the second part of the OSHA update, that OSHA clarified its reporting regarding when hospitalizations, COVID-related hospitalizations, have to be reported. Now, if you're familiar with the standard, you know that if there is a work-related fatality, that must be reported to OSHA within 8 hours of you learning of that. If there is a work-related hospitalization of just one employee, used to be 3, and about a few years ago, OSHA changed that. So any hospitalization of just one employee needs to be reported to OSHA within 24 hours. But what if this is a COVID-related work-related issue? Well, OSHA issued a frequently answered question, or frequently asked question, saying an employee's been hospitalized with a work-related confirmed case of COVID. Do I need to report this hospitalization to OSHA? And OSHA clarified again that if it is inpatient hospitalization, must be done within 24 hours. But here's the key response that they gave. For cases of COVID, the term incident means an exposure to COVID in the workplace. Therefore, in order to be reportable, an inpatient hospitalization due to COVID must occur within 24 hours of an exposure to COVID at work. The employer must report such hospitalization within 24 hours of knowing both the employee has been inpatient hospitalized, and that the reason for the hospitalization was a work-related case of COVID. So with that guidance, you should know that not a lot of hospitalizations will be reportable, because it has to be a hospitalization within 24 hours of being exposed to COVID. That is separate from fatality, because if you know that somebody was exposed to COVID and they've been hospitalized, and unfortunately if they pass away, that has to be reported within 8 hours. But the hospitalization itself is under OSHA's new guidance. It only needs to be reported as COVID related if that exposure occurred within 24 hours of the hospitalization. So that's what's going on with OSHA, and I will turn it back to Pete.
Mike, thanks. Appreciate the update. We're going to turn now to Katie Anderson and Adam Master-Leo. Katie and Adam are going to take us through, some of these recurrent questions. Katie will talk about what's going on, in Albany, but we thought we'd do it in the context of, travel, return to work, cluster developments, questions that we just keep getting because they're complicated, and the guidance is evolving. So take it away.
All right, Adam.
Yes, Katie.
You have an intro.
Yeah, so Katie and I are going to do something a little different today. We both have talked to you about various requirements on many of these webinars. We're going to approach this in a little bit of a tabletop exercise where Katie's going to give me some scenarios, and then we're going to walk through how you would respond to them as an HR person in your business. So with that said, Katie, let's get it started.
All right. So first one we've got is if you have an employee testing positive, what do you do? Is that employee entitled to sick leave, and when can they come back to work?
All right. So this is a question that we get a lot. And you as an employer, when you get somebody who tests positive, I've talked to lots of clients who've said, okay, now what do we do? So first of all, your first question is, can the employee work? And the answer in almost every circumstance when somebody tests positive is going to be no. So they have to go home. They have to stay home. All right. The second question is, are they going to be entitled to any type of paid leave? Remember, there are two different types of paid leave available. You have New York's emergency paid sick leave for COVID, and then you have the Families First Coronavirus Response Act paid leave for COVID. So under either of those statutes, you're going to have this employee who's tested positive entitled to receive paid leave. All right, so now you know the employee has to be out of work. You know the employee is going to be entitled to paid leave under one of the COVID statutes. So the next question is, what do I have to do as the employer? According to New York's guidelines, you have to communicate with your local health department. So you have to call the local health department. Now, in practical application, the local health department already knows about this positive test, but it doesn't relieve you of your obligation to contact them. So you contact your local health department. You have to make sure that you clean any areas where the positive employee was. You provide notifications to other employees as necessary. I would say that you're going to rely on the local health authority for certain specific communications that you're going to give. You don't want to give any communications to other employees that might violate HIPAA or provide information, not HIPAA, but provide sensitive medical information. So you want to be careful about information you provide to other employees. In that scenario, you're going to really take the lead, like I said, of the local health department. All right, so the employee's out. You've taken your necessary steps according to your reopening plan, what your plan says to do, who you have to communicate with. You've made sure that the employee is getting paid under one of these two statutes. The final question is, of course, when can this employee come back to work? And for an employee who tests positive, we've talked in the past about potentially conflicting guidance from the state. If you recall, there's March 31st guidance that was issued before any of the phased reopening began that applied specifically to essential employees. Then there was May 31st guidance that was issued that applies to everyone. We don't know for sure whether the May 31st guidance superseded that March 31st guidance, but we believe that it did. So you're going to want to make sure you understand which return to work guidance applies to you. And it might depend on where you are in the state and what your local county health department is abiding by. But if it is the May 31st guidance, like we believe it is, an individual who tests positive cannot return to work until they've completed 10 days of isolation from the onset of symptoms or from the date of the positive test. So it's one of those two things. And after that, the employee can return to work. So those are all of the steps that you're going to want to take if you have an employee who tests positive. Katie.
That's a lot of steps, a lot of things to remember there. You know, one of the really common ones that I keep, hearing about is whenever you have an employee that's symptomatic, but did not have close contact with someone. What do we do in that instance?
So this is a complicated question. You have the positive test. You have the scenario where someone has close contact with someone who's tested positive. And then you have what Katie just talked about, someone who's symptomatic, but who doesn't have close contact with someone who's tested positive. The first question that we ask, just like with the positive case, is, can this employee work? And unfortunately, I don't know that there is clear guidance out there to answer that question for you. We get the question a lot in the context of, this employee has allergies. We know it's not COVID related, but they're experiencing a symptom that is associated with COVID per the CDC. So can that person work? There isn't clear guidance. If you look at the return to work guidance, it just says that if someone is symptomatic, they have to stay out of work until 10 days from the onset of symptoms or until they get a negative test, one or the other. Because there isn't clear guidance, you have to take you can take a conservative approach, and you can say, if you're symptomatic, you have any of the symptoms, you have to stay home. Or you can take a more aggressive approach and say, if you have symptoms and those symptoms are clearly attributable to something other than COVID, and you can provide a doctor's note that says that then you can continue to work. But that's a much more risky approach. In the absence of guidance, the answer isn't entirely clear. So unfortunately, we don't have a very clear and specific answer in that situation. The analysis remains the same though. You go through, can they work? What steps do I have to take? If you have someone who's symptomatic, you don't have to notify the county health department. That obligation only arises when there's a positive test. Then the question is, are they entitled to paid leave? Well, it depends if they fit within one of the categories. Paid leave under the FFCRA. Remember, state paid leave is not available unless you're subject to a quarantine order. FFCRA leave provides additional categories, such as you're seeking medical treatment or a doctor has told you to stay out of work. So they might be entitled to paid leave under the FFCRA if they're symptomatic. And then the last question is, when can they return to work? Like I said, according to the May 31st guidance, you can return to work 10 days after onset of symptoms or upon receipt of a negative test. So you'd proceed through the question of a symptomatic, what to do with a symptomatic employee in that way. Katie?
A really good question that we keep getting is basically, what do you do when the employee can work remotely or can telework?
Yeah, that is a very good question. And the answer is, if they can work remotely, let them work remotely. That way, you're not going to run into any of the issues with having them in person. You can continue to pay them. They wouldn't be entitled to leave because they'd be continuing to work. So that is a good question. But if you have someone who can work remotely, let them work remotely.
One thing to remember there too is that New York State guidance officially, it all says that everybody should be continuing to work remotely to the maximum extent possible. That has not changed throughout all of this. Despite me being in an office today, that is still the case. And that may be pressed upon in the coming weeks, given the numbers and where things look like they are heading in New York and across the country. Let's do one more question too. What if you do have, you have an employee that is basically that they have the COVID-like symptoms, but they haven't tested positive. They've had close contact with somebody who had these symptoms, but that person who had the symptoms didn't test positive. What do you do in that case?
This is a good question. So we see this a lot. You have somebody at work who has had contact with somebody who has had contact with somebody who has symptoms. So, for example, and I set that up terribly. Let me try to clean that up. You have an employee at work who has a child at home who's sick. The child has a fever, but the child hasn't tested positive for COVID. Does that employee need to stay home because their child is sick? And the answer is the guidance doesn't require it. There's nothing requiring an employee to stay home if they've had close contact with someone who's symptomatic, but who hasn't tested positive. The obligation to stay home arises when the contact is with someone who's tested positive. So under that circumstance, you don't necessarily have to make the employee stay home. Now, many businesses are taking the position that they don't want someone who's had close contact with a person who's symptomatic to come to work, but that's a business decision. That's not something that's dictated by guidance.
And I think that we covered a lot in that time period, but we do have more to cover, so don't worry. The typical updates are coming to you now. First thing, last week we saw some major changes to the cluster zones in New York State. As you can see, I wanted to put this here because it shows the progress that's being made in these cluster areas, what the percentages are, which is a good thing to look at because it means that whatever we're doing is working. This is the new cluster zones that were designated last week are in Steuben County and Chemung County. Chemung has an orange and yellow zone. I'm not sure why the Broome got in there twice, why Steuben and Broome got there twice, but it is what it is. Chemung County is doing very poorly at this point on the prison outbreak in Elmira. is really just, it's not going well. So that could really affect what's going to happen in Elmira and in the areas related to it. Now, I also put up this map. I had this one up last week. I have an updated one today. The reason for that is we're looking to see where clusters going to be designated next. There is a good chance that the governor may come out tomorrow with new cluster zones that have been designated. He may wait until next week to do it with the updates with the other cluster zones. But I put this up here. This is still from the New York Times as well. This has the counties with the weekly cases per capita. As you can see, this is the southern tier of New York State, and things are, and then Rockland County. But there's a lot of things that aren't going well in that area, and I think that's going to really impact the thinking in that, what the governor's going to do with cluster zones. So I put that up there as a, hopefully that'll help guide us. But the biggest update then from last week too and this week is there are now actual metrics for when you get into a cluster zone. So I'm putting up these, I have each individual one up there. We had an information memo come out last week about this. If you have questions about it, if you want to look at these graphs more, or these charts more in depth, please go see that information memo. I will post it as soon as I'm done talking into the chat so that everybody can go see it, because it does show how we get into these cluster areas. It also shows how we get out of these cluster areas. And that will be helpful, for you in the future. So now we get to, these are just other factors that are in the cluster zone designation. All right, we flew through that, only to get to this. So this map is from last week. The governor has not gone on yet today and is currently not scheduled to. I suspect we'll see something around 2:30 or 3, but I could be wrong. And I have a prediction that this travel advisory, a lot of it's going to be changing. And because at this point, we've reached really no state can come into New York State. Like Massachusetts will technically qualify for the travel advisory based on the numbers I'm seeing out of Massachusetts, but because we are not, adding border states, we will not, likely see Massachusetts on the list. So we are, watching that very closely, and of course we'll give you updates when they come. One thing to note too with the travel advisory is last week, Hermes Fernandez and I had a call with a higher level, very high level official in the governor's office about travel to and from New York from Canada and how that impacts Canadian workers. That call, what we learned is there is an agreement between the United States and Canada that says that essential travel may continue between the countries and non-essential travel may not continue. So non-essential travel is tourism, recreation. Essential travel is everything else. So work. And in our conversation with the governor's office, came to light that, that would have some real federalism implications, and the state could be in, some serious trouble for trying to require Canadian workers that are commuting regularly to New York to quarantine. So these workers do not have to quarantine. So that is good. But if you do have questions on that, that was a real quick run through of that. If you have questions on that, give us a call. We would be happy to discuss. One last thing, this just came out right before we started, but SUNY is going to require that all students who are returning home, all in-person students who are returning home for Thanksgiving break, receive a negative COVID test before they leave. So they will have to receive that test 10 days before they go, travel for the holidays, because they are not coming back after Thanksgiving. Whew. And with that, Pete, I think we did it.
Okay, thank you. That was a lot of material. I want to thank everybody for sticking with us today. We ran over a little bit, but we had a lot on our plate. We'll be looking for, certainly some updates on the travel advisory in the coming week, and we'll be following the other updates for you as well. So thanks everyone for being with us. Have a good, safe week, and we'll talk to you next week.